Thank you. Good evening and welcome to the December 14th, 2020 zoning hearing meeting. I'm Pamela Jo Hatley. I'll be serving as the zoning hearing officer this evening. If you will all stand as you're able, please, and we'll recite the Pledge of Allegiance. Again, I'm Pamela Jo Hatley, and I'll be serving as the hearing officer this evening. Before we get started with the agenda, I'm going to pass the meeting to Brian Grady with the Development Services Department to introduce the agenda changes, withdrawals, and continuances.
Good evening, Madam Hearing Officer. Brian Grady, Development Services. We do have two changes on tonight's agenda. The first change is on page 7 of the agenda, item D4, the rezoning application PD 20-1149. The applicant is requesting a continuance to the January 19, 2021 zoning hearing master hearing. I believe the applicant is in present to explain the reasons for the request.
All right, applicant.
Good evening, William Malloy, 325 South Boulevard, Tampa, Florida. For this one, 1149, we received word from the Planning Commission, I believe it was the day before the continuance by right deadline, that they still found the project inconsistent. And we'd like to take 30 days to give it our very best shot at redrawing the project to see if we can get to the finish line there with them.
All right, thank you. Is there anyone here tonight who wishes to speak for the continuance as a proponent of the continuance? All right, is there anyone here tonight who wishes to speak against as an opponent of the continuance? All right, not seeing anyone, then item 20-1149 will be continued, and that is to the January 19th, 2021 zoning hearing master hearing.
The next change on the agenda is on page 7, item D5, rezoning PD 20-1248. The applicant is Bob Grove LLC. The applicant is requesting a continuance to the January 19th, 2021 zoning hearing master hearing. The applicant is here to explain the reasons for the request.
All right, applicant.
Yep. Thank you. William Malloy, 325 South Boulevard, Tampa, Florida. Again, this case is a very small, simple PD, but we discovered, I believe, actually on the day of the by right continuance, that if we went forward as we'd drawn it, we'd be leaving behind a non-conforming lot, which Development Services was not thrilled with. So we're redrawing that plan right now.
All right, is that it? Thank you. Is there anyone in the room or online who wishes to speak as a proponent of the continuance of this item? All right, is there anyone in the room or online who wishes to speak as an opponent of the continuance of this item? Okay, no one? All right, the continuance is granted, and this is item 20-1149. Did I get that right? 1248?
It's 20-1248.
Thank you. Item 20-1248 is continued to January 19th, 2021.
That concludes changes to the published agenda. I will now go through the published withdrawals and continuances beginning on page 4 of the agenda. Item A1, rezoning PD 18-0798. This application is out of order to be heard and is being continued to the March 15th, 2021 zoning hearing master hearing. Item A2, major mod application 19-0521. This application out of order to be heard and is being continued to the January 19th, 2021 zoning hearing master hearing. Item A3, rezoning standard 20-0144. This application is being withdrawn by the zoning administrator in accordance with LDC section 10.03.02C2. I would note for the record, we've handed out a change to this blurb. The continuance notice in the backup referenced the wrong petition number, so we've corrected the petition number to correctly reference 20-0144. Item A4, major mod application 20-0290. This application is out of order to be heard and has been continued to the January 19, 2020 zoning hearing master hearing. Item A5, rezoning standard 20-0312. This application is being withdrawn from the zoning hearing master process. Item A6, rezoning standard 20-0334. This application is out of order to be heard and is being continued to the January 19, 2021 zoning hearing master hearing. Item A7, major mod application 20-0377. This application is out of order to be heard and is being continued to the January 19, 2021 zoning hearing master hearing. Item A8, rezoning PD 20-0382. This application is out of order to be heard and has been continued to the January 19, 2021 zoning hearing master hearing. Item A9, rezoning PD 20-0394. This application is out of order to be heard and has been continued to the January 19, 2021 zoning hearing master hearing. Item A10, rezoning standard 20-0868. This application has been continued by staff to the January 19, 2021 zoning hearing master hearing. Item A11, major mod application 20-0898. This application is out of order to be heard and has been continued to the January 19, 2021 zoning hearing master hearing. Item A12, rezoning PD 20-0985. This application is out of order to be heard and has been continued to the January 19, 2021 zoning hearing master hearing. Item A13, major mod application 20-1068. This application is out of order to be heard and has been continued to the January 19, 2021 zoning hearing master hearing. Item A14, major mod application 20-1138. This application is out of order to be heard and has been continued to the January 19, 2021 zoning hearing master hearing. Item A15, rezoning PD 20-1142. This application is out of order to be heard and has been continued to the January 19, 2021 zoning hearing master hearing. Item A16, rezoning PD 20-1198. This application is out of order to be heard and has been continued to the January 19, 2021 zoning hearing master hearing. Item A17, rezoning PD 20-1252. This application has been continued by staff to the January 19, 2021 zoning hearing master hearing. Item A18, rezoning PD 20-1253. This application has been continued by the applicant to the January 19, 2021 zoning hearing master hearing. Item A19, rezoning PD 20-1255. This application is being continued by the applicant to the January 19, 2021 zoning hearing master hearing. Item A20, rezoning PD 20-1256. This application has been continued by the applicant to the January 19, 2021 zoning hearing master hearing. Item A21, rezoning PD 20-1257. This application has been continued by the applicant to the January 19, 2021 zoning hearing master hearing. Item A22, major mod application 20-1258. This application has been continued by the applicant to the January 19, 2021 zoning hearing master hearing. Item A23, rezoning PD 20-1264. This application is out of order to be heard and has been continued to the January 19, 2021 zoning hearing master hearing. Item A24, rezoning PD 20-1265. This application has been continued by the applicant to the January 19, 2021 zoning hearing master hearing. Item A25, rezoning PD 20-1266. This application has been continued by the applicant to the January 19, 2021 zoning hearing master hearing. And item A26, rezoning standard 20-1282. This application is out of order to be heard and has been continued to the January 19, 2021 zoning hearing master hearing. That concludes all withdrawals and continuances.
Thank you, Mr. Grady. All right, I'm going to go over a few procedures for the meeting this evening. First of all, the agenda items tonight are items that require a public hearing by a hearing officer before going before the Board of County Commissioners for a final decision. I will conduct a hearing on each item on the agenda and will submit a written recommendation. My written recommendation will be filed with the clerk of the Board of County Commissioners within 15 working days after conclusion of today's public hearing. The Board of County Commissioners will consider the record of today's public hearing and my recommendation, and will make the final decision on the application at a publicly noticed meeting on a date and time set by the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but the evidence will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact, unless it would be admissible over objections in a civil court action. The order of presentation for tonight's hearings will be first, county staff, Mr. Grady, will introduce each item. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. County Development Services will then have 5 minutes to present its findings and recommendations. The Planning Commission will have 5 minutes to present its finding of compliance or non-compliance with the comprehensive plan. Proponents of the item will have 15 minutes to present arguments in support of the proposal. Opponents will then have 15 minutes to present arguments against the proposal. And then county staff will have 5 minutes to present any amended recommendations. And finally, the applicant will have 5 minutes for rebuttal and summation. The 15 minutes for proponents and opponents is the total time allotted among them. So if there are a number of persons who wish to speak on an item, the 15 minutes will be distributed among them. If that's the case, then you may wish to designate a single spokesperson to represent your views. When you come to the microphone to speak, please first state your name and address for the record. This meeting is being recorded. Please speak into the microphone so your testimony can be heard and recorded. When you're finished speaking, please see the clerk on my right to sign in for the record. We'll need your name, address, and the application number that you're speaking to. Now, I wish to call Assistant County Attorney Cameron Clark to state the legal requirements for requesting oral argument at the public hearing where the Board of County Commissioners will make a final decision. Mr. Clark?
I understand that Mary Dorman with the County Attorney's Office will be making that presentation.
Thank you.
Hi, this is Mary Dorman from the County Attorney's Office. Tonight's public hearing is the first step of a two-step rezoning process. This hearing is the time for rezoning applicants and interested parties to present testimony and evidence. Any evidence presented tonight will become the complete factual record of each application, and no additional evidence can be introduced after the closing of each application. The second step of the rezoning process is a public meeting before the Board of County Commissioners, where the board will take a decision on each application heard tonight. Tonight's applications are scheduled to be heard by the board at its February 9th, 2021 land use meeting. When considering applications, the board will only review the record created at tonight's hearing and the recommendation made by the hearing master for each application. The hearing master will file a recommendation for each application heard tonight on January 7th. The Board of County Commissioners has established a policy that directs which rezoning and major modification applications are to be placed on the consent agenda of the board's land use meeting. Applications that propose to add density outside the urban service area and applications that would result in a failing level of service on a roadway are not qualified for placement on the consent agenda. Applications which do not have consistent recommendations of approval or denial are also not qualified to be placed on the consent agenda. Please be advised that applicants and parties of record shall be required to submit a request for oral argument in order to address the board on these items. Any party of record wishing to address the board at its public meeting must execute and submit a request for oral argument form explaining why oral argument is necessary. Requests for oral argument must be responsive to the hearing master's recommendation. Therefore, such requests cannot be filed until after the hearing master has submitted his or her recommendation to the county on January 7th. Following this date, any party wishing to address the board at its public meeting will have 10 days to submit a request for oral argument to the clerk to the Board of County Commissioners. Therefore, for tonight's applications, if you wish to address the board at its February 9th, 2021 land use meeting, you must file your request for oral argument between January 7th and the close of business on January 19th. While the board is not required to hear oral arguments at its public meeting, the board can elect to hear oral argument from a party of record. A party of record is an individual who fits into at least one of the following four categories. First, an individual who is present tonight and presents testimony or documentary evidence. Second, an individual certified by the U.S. Postal Service as having been mailed notice of tonight's hearing. Third, an individual who submitted documentary evidence to the master file at least 2 business days prior to tonight's hearing, or fourth, an individual who submitted documentary evidence by proxy at tonight's hearing. Should the board elect to hear oral argument, parties of record will be eligible to address the board if their requests for oral argument are responsive to the hearing master's recommendation and if they clearly set forth why oral argument is necessary to address at least one of the 4 outstanding issues laid out in section 10.03.04E of the Land Development Code. If the board elects to hear oral argument, that the content of that argument shall be limited to the content of the testimony and other evidence submitted verbally or in writing to the hearing master tonight. It is the role of the county attorney's office to ensure that only individuals who have met these requirements are allowed to speak before the board and to ensure that no new evidence or testimony is introduced or allowed at the board's public meeting. For these reasons, please make sure that all information you wish the board to consider at its public meeting is entered into tonight's record.
Thank you, Ms. Dorman. All right, all testimony taken tonight must be under oath. So if you plan to speak tonight, all who are here in the room, and if you're online also, if you plan to speak tonight, please stand if you're able, raise your right hand, and I'll swear you in. Do you swear the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
Mr. Grady, would you please introduce the first item?
The first item on tonight's agenda is item C1, rezoning standard 20-1171. The applicant is Tampa Electric Company. The request is to rezone from AR and PD to AR. Colleen Marshall will provide staff recommendation after presentation by the applicant.
Applicant, thank you.
Good evening, Madam Hearing Officer. Kristen Mora, Tampa Electric Company, 702 North Franklin, Tampa, Florida, 33602. I am here tonight representing Tampa Electric Company. We are seeking to rezone the property to agricultural rural. The property is currently in agricultural use, and we intend to use it for agricultural use in the near future. The plan development that was approved was for residences, and Tampa Electric is not in the business of building residences. So we're taking it back to the original agricultural use that it was rezoned from. We also have a companion application, which I believe is item D2 on your agenda tonight, that is to remove it from the current plan development. And I'm available if you have any questions.
Thank you very much. I have no questions right now. Is there anyone here tonight who wishes to speak to?
We need to hear from staff.
Oh,
first.
I'm sorry.
That's okay.
I'm getting ahead of myself. Thank you, Mr. Grady.
Good evening, Colleen Marshall, Development Services. The applicant stated the request is to rezone from planned development, agricultural rural, and agricultural single family to agricultural rural. Companion major modification 20-0801 is scheduled to move forward concurrently with the proposed rezoning to remove the subject area from the existing PD. The surrounding area is primarily agricultural development with single family residential developments in the area. Proposed rezoning will bring the subject property back to the AR zoning district as it was prior to the 2007-2003 PD rezonings and maintain the rural agricultural character of the area. No agency objections were received by staff, and staff recommends approval. I'd be happy to answer any questions.
Thank you, Ms. Marshall. I have no questions for you right now. All right. Planning Commission?
Ms. Hemingway, you're muted.
Thank you. Sorry about that. Unique Mills Planning Commission staff, the subject property is located within the agricultural rural 1 and 5 future land use classification and the residential 1 future land use classification, the rural area and the South Shore area-wide systems, and Little Manatee South community planning areas. The applicant is requesting a rezoning to agricultural rural. The zoning district is consistent with the residential 1 and agricultural rural 1 to 5 future land use classifications. The area is a combination of agriculture and residential land uses, which is compatible with the applicant's request. The request is consistent with Objective 4, as the subject property is within the rural area, which is to provide for long-term agricultural uses. Objective 6 and its accompanying policies, 16.2 and 16.3, require the protection of existing neighborhoods. Specifically, 16.3 states that development shall be integrated with adjacent land uses that are complementary to the development pattern. The proposal to allow agricultural uses should not impact the residential. The proposal therefore meets the intent of Objective 16 and its accompanying policies. The proposal also meets the intent of Objective 13 and, Objective 30 and Policy 30.5 and 30.6, which encourage agricultural and agricultural related uses in the rural area. Overall, the proposed rezoning would allow for development that is consistent with the goals, objectives, and policies of the unincorporated Hillsborough Comprehensive Plan. Based on those considerations, Planning Commission staff finds the proposed rezoning consistent with the future Hillsborough Comp Plan. Thank you.
Thank you, Ms. Mills. All right, now, are there any proponents in the room or online who wish to speak to item 20-1171? Okay. All right, I don't see any proponents. Is there anyone in the room or online who wishes to speak in opposition to item 20-1171? All right, I think
Yes,
We have Robert Knowles.
I have some questions.
We'll start with Robert Knowles. Can you hear us?
I'm not sure if you can hear me. My name is Robert Knowles. I live
Robert, you do have to enable your camera.
at G7 Ranch Road in Ruskin, which
Robert,
is
you do have to enable
directly
your
across from the proposed.
Robert.
Knowles, I think we need video, right?
I have,
Mr. Knowles, can you put on your video, please?
I'm sorry, say again?
We need your video.
Do you have it now?
Please enable your camera, sir.
I believed I had it
Now we're good.
enabled.
Would you please restate your name and address? Thank you.
I can do that. My name is Robert Knowles. I live at 3402 G7 Ranch Road in Ruskin, which is directly across from the proposed application.
Go ahead, please.
Okay. Agreed that Tampa Electric Company is not in the business of developing residences. I have been led to believe that this project is in aid of putting up solar panels for electrical generation, but that's not been mentioned here tonight. Is that in fact the case?
This application tonight is for a rezoning to agricultural rural. There's no development on the agenda for me to review tonight, only the rezoning.
So so my objection would be then that the applicant is unclear as their true intended ultimate use.
Is there anything else, Mr. Knowles?
That was a question.
Well, that was a question, but if that's the case, I don't know what further I can say. I'm aware that Tampa Electric Company is not in the business of agriculture, so they are in the business of generating electricity and serving people, and so to that end, I'm unclear and would like further clarification if possible.
Okay, the rezoning is again to agriculture rural. The land development code allows certain uses under that zoning designation, and the uses that are allowed under that zoning designation, the property could be used for if the rezoning is approved. any other objections or any other statements you wish to make, Mr. Knowles?
No, evidently, I need to acquaint myself then with what uses Tampa Electric Company can use the property for with an agricultural zoning.
All right. Thank you, Mr. Knowles.
Next up, we have Margaret Knowles.
Good evening. Truthfully, at this point in time, I don't think there's any further discussion that should come from us. It was our understanding that this wasn't not just a rezoning change, but it was also going to give the residents and people in the direct neighborhood an opportunity to get some clarification and get some answers to the ongoing questions that we have regarding these various parcels. There is the G7 one, and I believe altogether there's 4 different parcels of property. So truthfully, we would like clarification. We have personally spoken with Tampa Electric Company, and they did tell us that they were going to try to do solar panels. And so for that not to be disclosed this evening is a little bit difficult for us to be supportive or not be supportive. And we would like to be good neighbors, but we would like clarification and to know what's going to be physically living across the street from us, where we've been in this residential area for 30 years. So any additional information that Tampa Electric can provide to the people that have lived out here for all of these years, we would greatly appreciate it. Thank you.
We'll have the applicant come back in just a moment. We'll hear from, are there any other opponents? One more.
I want you to please state your name and address for the record.
Please.
Ms. Knowles, you're muted. Go ahead.
Are you ready? Okay, it was Margaret Knowles, physical address 3402 G7 Ranch Road, Ruskin, Florida 33570. And my husband and I live directly across from the 20-0801 applicant.
Thank you, Ms. Knowles.
Thank
And I
you.
believe we have one more person online as an opponent.
Our final speaker is Nancy Cunningham.
Yes,
Nancy, just please state your name and address when you start your testimony.
yes, it's Nancy Cunningham. I live at 3406 G7 Ranch Road, Ruskin, Florida, 33570. My question will also be directed to Tampa Electric. I would like to know what they're going to do with this property. It is unclear. We were discussing that it was going to be a solar panel farm, and all of my questions are directed to that. What are they going to be doing with the property? It is very important to me. I live directly across from where they're going to be developing. So I would like to know what's taking place out on that property.
Thank you, Ms. Cunningham. Is there anything else you want to add?
Right now, I don't want Tampa Electric there. I'm going to be honest.
Specifically object to a solar facility, a solar installation?
I won't necessarily object to the solar installation itself, but right now, because they're not clarifying what is going to be placed down on the property, I object to them being out there at all. So without direct clarification with specific information regarding what they're planning to do with the property, I'm not happy with the unknown.
All right, thank you, Ms. Cunningham. The applicant will be back up in just a moment. Is there anything else you wanted to add?
If this is going to be a solar farm, I have a series of questions that I would like answered.
All right.
Madam Hearing Officer, I can advise that the AR zoning district does permit a solar farm, but again, as you correctly pointed out, this is an AR zoning, so there's no specific provision at this point that would dictate what they can and can't do with the property, but that certainly is a permissive use on the AR.
Thank you, Mr. Grady. Did you hear that, Ms. Cunningham?
Yes, ma'am, did.
So a solar farm is a permitted use. But this is not the process where that use is being requested. This is just a rezoning to AR.
Then I will honestly say that unless they can specifically tell me today what they're going to be doing, I am not happy with the zoning.
Okay. Thank you, Ms. Cunningham.
Thank you.
All right. Back to development services. Any comments?
Nothing further.
Okay. All right. Would the applicant come back up, please? 5 minutes for rebuttal, or?
That's fine.
Okay.
Good evening again, Kristen Mora, Tampa Electric Company. We do not have concrete plans for this property as of yet. It could be a solar farm, but we do not have concrete plans for this property. When we do develop the property, we will certainly engage the neighborhood out there. We will let them know exactly what our plans are. We'll share with them. We always set up community outreach meetings when we're actually ready to develop a piece of property. And so we will reach out to them at that time and share all this information about what the solar panels will look like, what they can expect, both during and post-construction with the property. But we don't have concrete plans for this property this time, which is why agricultural rural was a good fit. It's consistent with the use on the property today, which it's currently being farmed. We regularly enter into agricultural leases for property, so that's what the property is being used for today. And that's what it'll be used for until we have concrete plans for the property.
Ms. Mora, were there any meetings with the community so far? Did the applicant have any meetings with the community?
We have not had any meetings with the community. We've been trying to be sensitive to COVID-19 and not ask people to come out and meet us in any way that would make them uncomfortable. We have answered some phone calls from neighbors in the area asking about it, and they heard exactly the same response that you just heard, which is that it's a potential for the property, but we don't have concrete plans for it yet.
Okay. And then you just stated when Tampa Electric decides what to do on the property, that there will be meetings at that time?
There will definitely be community outreach meetings at that time. I don't know where we're at. We usually, would do some sort of public outreach initially. That doesn't require people to come out. And then at that point, hopefully we'll be in a situation where we can hold an in-person meeting again, and they can meet everyone that's going to be working on the property, and we'll have our more traditional meetings. We've been having to do them a little bit virtually of late, but that's certainly our hope. And we shared that for everyone who called as well, that it's definitely our intent to have a public meeting, as we always do, and let everyone know when we have an idea of what we're going to be doing and when. Okay, we'll be doing that.
Thank you. I have no more questions. You have anything else to add?
No, that's it.
Okay. All right. Thank you very much.
Thank you.
All right. This will close the hearing for rezoning 20-1171. Mr. Grady, will you call the next item, please?
The next item then is agenda item D1, rezoning PD 20-0103. The applicant's Waterford Construction and Development Incorporated. The request is for a rezoning from PD to PD. Laura Marley with county staff will provide staff recommendation after presentation by the applicant.
Thank you. Applicant?
Good evening, Madam Hearing Master. For the record, I'm Michael Horner, 14502 North Dale Mabry Highway, Tampa 33618. Representing Mr. John Westfall, Waterford Construction Development, who's the applicant and contract purchaser. With me tonight is Mr. Westfall and Nikki Blaine of Waterford. We also have Mr. Michael Yates of Palm Traffic Engineering, who will be testifying briefly. As well, remotely, we have Mr. Jeremy Couch of Tampa Civil Design, and then possibly on rebuttal, we will have Mr. Ken Jones, professional hydrogeologist. So, Ms. Alley, it's a little bit interesting. I have a 43-year-old car that I accidentally locked my keys in tonight, which includes all of my files and notes and so forth. However, I've worked on this case for almost a year, so I'm more than prepared to proceed, but I'm not wearing a suit coat, which is in the car, so I apologize for that. So staff and ourselves have been working diligently, Ms. Hatley, for at least a good part of a year. We had COVID delays, of course, and then we ramped up our filing and reviews probably last 3 months. We are pleased to stand before you tonight With unanimous recommendations from both the Planning Commission and Development Services, we're recommending approval with conditions that we have no objections to. This is a 4.8 acre site. It is located north of Moran Road, east of Dale Mabry. Dale Mabry is a 6-lane divided arterial highway. Moran Road is noted in the Planning Commission report as a collector roadway. We are directly abutting OC 20 commercial corridor on North Dale Mabry Highway. Those uses specifically are a Firestone automobile service station, or actually a service repair facility. Then we have strip commercial on the west side, directly abutting our client's proposed office park. That pattern has existed for years. This property was initially rezoned, I want to say back in 2006, for 16 attached and detached homes. You can imagine why it's still undeveloped. It's very difficult to market single-family homes next to open service bays where they have tire changes, pneumatic tools. It's rather noisy. They're also open Saturday, Sunday, and Monday through Friday with extended evening hours till 6 or 7 o'clock, I believe. This is 4.8 acres. Approximately 1.2 acres are wetland designated by EPC. We do have that delineation. We also have the balance of that as being 3.6 acres as upland. We are not encroaching at all in Little Bay Lake. We actually have our proposed retention pond as the buffer to the lake, and therefore we will not have any impacts or encroachments. We do have a 0.15 acre EPC designated isolated wetland internal, and that has gone through EPC for review. And we will be seeking those permits and approvals in the next month or two. We're buying credits to the mitigation impact bank. I'm going to ask Jeremy Couch, who is remote, if he could log on so that we can share screen and we can go through the site plans that we filed and then the amendments to those plans. If Mr. Couch could go live. Perfect. So if we could just zoom out, Jeremy, a little bit, if possible. So here's our, and Jeremy, let's go to the first plan, please, the existing, and then we'll go to the proposed. So Ms. Hatley, this was initially filed for 35,000 square feet. And staff had some objections to that. And we worked very hard on trying to come up with solutions. That plan before you had 10 buildings, 5 buildings on the east side, including one a little bit north of the parking bay, and 3 buildings on the west side. Access remains unchanged. It's aligned with the Grove Financial on the south side. However, it's important to note that the Bay Lake Lane actually encroaches onto my client's property that he is purchasing. You can imagine the hardships encountered when the final surveys came in. And we realized that the county has an existing roadway that serves those residents to the east and north on our property, rather substantial encroachment, 10 to 12 feet. So we modified our plan and we allowed for a buffer design variation that would have reduced that buffer to 9 feet and still kept the 10 buildings. Staff and us had further reviews and further dialogue. And you can see that slight buffer on the east side. Staff had concerns and expressed those in several Zoom meetings we had, that was insufficient. And they thought with Bay Lake Lane now being reconstructed on the east side, we're giving that property to the county at no charge. Those buildings are a little closer to Bay Lake Lane, a little bit closer to the eastern residents, and therefore they expressed some objections to that. Next plan, Jeremy, to what we're proposing. We went back to the drawing board and moved all of those buildings, Ms. Hatley, to the west side. And we reinstated that buffer on the east to the full 20-foot type B with full screening per section 606. So not only tree planting, but fencing. We have the horizontal 20-foot buffer. And again, you can see the encroachment of Bay Lake Lane into our client's property. We are now shifting everything to the west, so the county does not have to rebuild Bay Lake Lane further east. Jeremy, if you can note that eastern right-of-way line to existing Bay Lake Lane, I mean, you can see that is a considerable distance to the east. We felt that it was not necessary to have the county relocate Bay Lake Lane at great expense. We then modified our plan. Therefore, it's a win-win. The county gets to keep Bay Lake Lane where it is. We allow for that accommodation. The residents have their access unchanged, and we now have reinstated the full 20-foot buffer with tree planting. So the buildings that we are now proposing, the last plan was 35,000 square feet, 10 buildings, averaging 3,500 square feet. We are now at 8 buildings at 26,500 square feet. For comparative purposes, we are in Res 4, although we're directly abutting OC 20. If we were doing a more intensive project, we could flex that OC 20 and get a much higher FAR 0.75. So here's the zoning map. You can see on the south side, we have the bank. On the west side, you can see the Firestone footprint right there. They have access to both Dale Mabry and to Moran Road. We are providing cross access to Firestone. You can see the shopping center directly north, and we're behind all of those buildings, grease trap stations, the service dumpsters, not the most ideal transition for residential. So we think office is the most appropriate transitional district. And then Bay Lake Lane continues to serve those residents. The closest residence to the east is over 200 feet on the east side of Bay Lake Lane. So certainly more than adequate buffer between our proposed use and existing residences. Let's go back to our plan, Jeremy, please. For comparative purposes. And Allison, if I can just get a flag at 9 minutes, please. All right, very good. For comparative purposes, Ms. Hatley, being Res 4, you're aware 0.25 is the FAR cap. Even looking at the density transfer provisions for wetlands for FAR, we could still request up to 49,000 square feet on this 4.8 acre tract. That's a lot of square footage, and we never considered that. However, we did look at perhaps a 0.20 intensity that would be a BPO level, not the full max of the Res 4.25, but BPO does allow 0.20. Even that would allow 39,000 square feet. So I provide that as a level of comparison in terms of intensity between maximum permitted, not an entitlement, it's a maximum that's you can request under the BPO at 0.25 or 0.20, and then we are at 26,500 square feet, 13,000 square feet under the BPO standard. We have worked hard with staff. We have gone through a number of provisions. We stand before you, as I said, with unanimous recommendations. Moran Road does connect through. It comes through Dale Mabry from the east side. It dovetails to the south, and then it goes due east, and that connects all the way to Lake Magdalene Boulevard and also Orange Grove further east that runs north-south. So this roadway certainly contains collector traffic and distributes that traffic to the arterial network, which is Dale Mabry Highway. The uses to the south of Moran Road are the bank. We also have a synagogue on the east side of Moran Road. We have veterinary offices and professional offices on the west side of Moran. So office clearly has been an appropriate transitional use district throughout the Dale Mabry corridor. Lastly, we have also agreed, and Jeremy, if you can just slide over to the elevation. We have agreed to condition this with an illustrative elevation, and we're binding ourselves to 1 story, 25 feet in height, architectural design features. That's not the exact building, but that gives you an idea of an illustration exhibit of what my client will be constructing. So again, the maximum size in addition to those elevation requirements, we have agreed to not to exceed 4,500 square feet, which is a large single family home. Now, 4,500 times 10 buildings is 45,000, 4,500 times 8 is around 40,000 square feet. You can see that we are well below those thresholds at 26,500 square feet. Average building size, somewhere between 2,000 and 4,000 square feet maximum. We are also proposing sidewalks. The county has required sidewalks on the east side of our project. We would have loved to have constructed those sidewalks east of Bay Lake Lane where we have the existing right-of-way. However, we were advised that that is not possible, that we could not ask for the placement of the sidewalk there. We have an existing termination of sidewalk east of Moran Road at the south side. It would make logical sense to extend straight up on the east side of Bay Lake Lane and connect with where those residents are being served. That cannot take place. We're sorry, it can't. We think that's logical, but we now have constructed or are proposing to construct a brand new 5-foot wide sidewalk just next to our buffer west of Bay Lake Lane. We're also doing sidewalks on Moran Road. Planning Commission did require a locational criteria waiver. We're not quite sure why that was required. I think it's because of the adopted plan for 2040 as opposed to the needs plan. We are well within the locational criteria nodal of 900 feet in Res 4. However, they asked for it, and we provided that, and it's incorporated into my narrative under my PD report. We reached out to the neighbors, had a Zoom meeting, tried to address all of their concerns. We feel that this amended plan certainly allows for that transition. We cluster our buildings next to the most intensive OC20, CN, and CI uses to the west, and then we have a passive parking lot and the 20-foot buffer and the sidewalk. Office uses are transitional to residential because they're quiet, they're closed during evening hours, and they're closed on weekends. So with the residential design, the conditions, we think this is the ideal use, and we're pleased to stand before you with unanimous recommendations for approval. I'm going to have at this time Jeremy just address stormwater management and EPC issues, and then we have Mr. Yates address transportation improvements briefly.
It looks like you have about one minute and a half.
Or the full 15. I wanted 9 minutes total. All right, so I'm going to have Mr. Yates address briefly transportation. I think we'll go back on rebuttal. So thank you very much.
Thank you.
Good evening, Michael Yates, Palm Traffic, and I have been sworn 400 North Tampa Street. I'll be very brief. We have let me see, let's get this direction right. There we go. So we have, from a transportation perspective, we have a design exception for Moran Road. What we are proposing is a 3-lane section, basically adding a left turn lane in Moran Road. So we are going to maintain the existing 10-foot lane, so we'll shift a little bit, do a Miami curb. And so basically at the intersection of Bay Lake Lane and Moran Road where it turns today, we're going to make that a T intersection and do Miami curb through here, through this section. So that is our design exception. The county engineer has found that approvable. We also have a administrative variance for driveway spacing. We have located our driveway just to the east of the curve here, but we're aligning with the Grow Financial over here. In discussions with staff, we figured that was the best location, keep that alignment, and that's our administrative variance. The other thing I just wanted to bring to your attention, and as part of the record, is that in our discussions with county staff, DOT has a safety upgrade they're looking at the intersection of Dale Mabry and Moran Road, which would potentially make that a directional median opening. So eliminate the left out that could occur there.
Okay.
I will enter into the record, the report from DOT.
Give him one more minute, please. Is there also a turn lane queue design exception that you wanted to speak to?
So there's a left turn lane design exception. We were working through those details with the county engineer, but because of timing issue, we'll work through that design exception as part of the construction plan process. That wasn't needed for the zoning.
Okay, and you did say DOT, you got 30 seconds. DOT is making improvements on Dale Mabry?
Yeah.
Explain that a little bit more, please.
Sorry. So basically at the intersection of Del Mabry and Moran Road, DOT did a safety analysis of this intersection, and what they are looking at doing is putting a directional median opening in the intersection. So basically eliminating the left out that can occur there today to get rid of the safety and operational issues that they have concerns with. That would be a safety upgrade. So the timing is a little questionable because it's not a typical CIP project. It's part of their operations group and a safety improvement. But I'll enter this report into the record for your.
Okay, thank you. All right, that's it for the applicant. Development Services, please.
Good evening, Laura Morley, Development Services. The applicant is requesting to rezone approximately 4 acres from planned development to planned development, 26,500 square feet of professional/medical office space. Natural Resources reviewed the application, has no objections, and have recommended condition as the presence of nearby bald eagle nests are on site. The Planning Commission finds the request consistent, and staff finds the application approvable subject to the conditions based on the site plan submitted January 2nd, 2020. Thank you.
All right, thank you. Planning Commission?
Unica Mills Planning Commission staff, the subject property is located within the residential 4 future land use classification, the urban service area, and the Greater Carrollwood Northdale community planning area. The request for a general and medical office buildings 500 square feet is consistent with the residential 4 future land use classification. The subject property does not meet commercial criteria. Moran Road not being on the highway cost affordable map. A waiver to locational criteria has been requested. The proposed rezoning has demonstrated a gradual transition from appropriately scaled office uses to single-family residential uses to the east through site planning, buffering, and screening. The proposed office use also serves as a buffer between the more intense commercial uses along Del Mabry and the single-family residential uses to the east. The proposed rezoning is compatible with the area and fulfills the intent of policies 1.4, 16.1, 16.2, and 16.3 of the future land use element. Planning Commission staff recommends that Hillsborough County Board of County Commissioners approve the waiver to locational criteria. Goal 2 of the Greater Carrollwood Northdale Community Plan requires that new development and redevelopment use compatibility design techniques to ensure the appearance, architectural style, mass, and scale of development is integrated with the existing suburban nature of each neighborhood. The proposed office use provides an appropriately scaled transition to nearby single-family residential development without the encroachment of intensive commercial development, consistent with the vision of the Carrollwood Northdale Community Plan. There are wetlands present on the subject property. The Environmental Protection Commission Wetlands Division has reviewed the proposed rezoning. The EPC has determined that a resubmittal is not necessary for the plan's current configuration. Overall, the proposed rezoning would allow for development that is consistent with the goals, objectives, and policies of the future land use element of the unincorporated Hillsborough Comp Plan. And based on those considerations, Planning Commission staff finds the proposed major modification consistent with the future Hillsborough Comp Plan. Thank you.
Thank you. All right, are there any proponents for this item 20-0103? Any proponents in the room or online who wish to speak? All right, don't see any. Are there any opponents who wish to speak to this item in the room or online? All right, none. Thank you. County Development Services, any changes?
Nothing further.
Okay. Applicant?
Thank you. Ms. Halley, Michael Horner again for the record. We do have an expert that I'd like to at least introduce himself. Just because there's testimony and written work product filed in the record regarding that wetland and potential concerns over contamination, our expert has looked at it. And if I can have Ken Jones, if he could just jump online and address his qualifications first, Ken, and then address the basic of your findings on that contamination issue. Thank you very much. And I'll close on the rebuttal.
Hello, can you hear me?
Yes, we can. Go ahead.
Oh, good deal. Yeah, my name is Kenneth Jones. I'm a professional geologist, licensed in the state of Florida. Oh, I get something to cover my, there you go. That's better. Anyway, I'm a professional geologist licensed in the state, and I have looked at some testimony provided by Peter Schroeder, and I agree with the findings of his testimony with one small difference. And basically, a sinkhole is a breach in the aquifer, and a breach in the confining layer above the aquifer that causes a direct conduit and for contamination. So if there was any contamination that is coming off of Dale Mabry into that sinkhole, then it is being not filtered, and it could cause contamination of the groundwater. Our proposal to replace that sinkhole with a permitted stormwater pond is actually much beneficial for the Florida aquifer and the water quality as a whole. That's basically it in a nutshell.
Can you please state your address for the record?
Sure, it's 4806 West Azeel Street, and the name of the company is Hydro Environmental Associates.
Thank you.
Just a quick question. Are you referring to the, well, we've been calling it Bay Lake, I think, on the north side of the property? Is that the sinkhole you're referring to, or are you just speaking in general as sinkholes?
No, ma'am, there's, in the middle of that property, it is actually considered a wetland in the, on the drawings. There you go, right in the middle. That is actually a little bitty sinkhole, or it's been referred to as a sinkhole. And in Peter Schroeder's testimony, he's suggesting that flow off of Dale Mabry Highway is going into that sinkhole and creating a protective bubble around the area. And what I'm trying to suggest is that, yes, it's creating a bubble, but that bubble could be contaminated water because it's not getting filtered. A sinkhole doesn't provide a good filtration. It's a direct conduit between the ground surface and the groundwater below.
And then your point is the retention area that's going to be, that's part of the site plan, that retention area will collect that runoff or contamination and treat it at that point. Is that what you're saying?
Yes, ma'am. Yes, ma'am. It'll treat it, and it'll actually create a much better quality of water that's allowed to recharge into the aquifer. It's much better.
I understand. Thank you.
Thank you, Ms. Haddon.
Mr. Horner?
Yes, that was the point that we were trying to make on the rebuttal, that in fact, this will all be engineered through a stormwater management system. We will collect it. Now that we have fewer buildings, less impervious surface, discharge it, filtration pond, pre-treat, and then discharge into Bay Lake as a much cleaner source water that's currently coming across Dale Mabry today. We thank you for your time. Look forward to your recommendation. Thank you very much.
Thank you, Mr. Horner. Mr. Grady, next item.
The next item is agenda item D2, major mod application 20-0801. The request is for a major modification of existing plan development. Colleen Marshall will provide staff recommendation after presentation by the applicant.
Applicant, please.
Good evening again. Kristen Mora, Tampa Electric Company, on behalf of the applicant. This is a request to remove the property that is on the south side of Stevens Road. It's a part of this plan development in order to rezone it to agricultural. As you heard earlier, the property that is within the plan development on the north side of Stevens Road will not be impacted. That will remain intact. It's just the property on the south road being removed. And I'm available if you have any questions.
All right. Thank you. All right, development services.
Colleen Marshall, Development Services. As the applicant stated, the request tonight is to amend the existing planned development located on the north and south sides of Stevens Road to remove the area south of Stevens Road from the PD zoning. This is the companion PD modification to rezoning 20-1171, which was item C1 on the agenda. No changes are proposed to the portion of the PD north of Stevens Road. No agency objections were received by staff, and staff recommends approval. I'll be happy to answer any questions.
Thank you, Ms. Marshall. Planning Commission?
Unica Mills Planning Commission staff, the requested major modification, Unica Mills Planning Commission staff, the subject property is located within the agricultural rural 1 to 5 and residential 1 future land use classification. It's also located within the rural area in the South Shore area-wide systems plans in the Little Manatee South Community Planning Area. The applicant's requesting a major modification. It is consistent with objective 4 of the future land use elements, as this is where 20% of the future growth is supposed to occur in the rural area. It is consistent with objective 16 and its accompanying policies 16.2, 16.3, and 16.10, which require protection of existing neighborhoods from various buffering and mitigation mechanisms. The proposal also meets the intent of objective 30, policies 30.5, policy 30.6, which encourages agricultural and agricultural related uses in the rural area. The Little Manatee South Community Plan identifies the subject site as being within the economic development area. Uses are to include, but are not limited to, biomedical, agribusiness, and green technologies. So allowing a solar energy generation facility as a permitted use to the existing PD would fall within green technology, which is consistent with the community plan. And based on those considerations, Planning Commission staff found the proposed major modification consistent with the future Hillsborough comp plan. Thank you.
Thank you, Ms. Mills. Is there anyone in the room or online who wishes to speak as a proponent of item 20-0801? Okay, none. Is there anyone online or in the room who wishes to speak as an opponent in opposition to item 20-0801?
Yeah.
Yes.
Okay. Yes, we have Robert Knowles we'll start with.
Good evening. I'm Robert Knowles. My address is 3402 G7 Ranch Road, Ruskin, Florida. We are directly across the street from the proposed change. Our objections are admittedly vague in as much as Tampa Electric has made no effort to share with us in any way what their true intentions are. Rather, they seem to be wanting to gather as much land and get it for the permitted uses that are already there, that being as a solar farm, which appear to us to be more of an industrial use as an agricultural. We're not experts in land use permitted items. So the area of concern to us is the impacts to us are unstated, vague, and not minor. So accordingly, we do object to the change until or unless we can understand that that our life, our quality of life that we've enjoyed for quite some time will not be negatively impacted.
Mr. Knowles, is that it?
I believe so.
Thank you, sir.
We also have Margaret Knowles.
All right, Margaret Knowles, please.
Good evening, Margaret Knowles, 3402 G7 Ranch Road, Ruskin, Florida, 33570. One of the things that Robert and I would like to basically emphasize is that we're not entirely in opposition. as a direct neighbor to this potential use. But what we'd like to be assured is that the land use and preparations for the land use do not negatively impact current or future qualities of life that our family has enjoyed for many years. We're also concerned about high potential voltage issues directly across from our property. And again, we both are not entirely in opposition to TECO or solar generation. It's simply that we don't have enough information based on what has been gathered before us even this evening for us to know what TECO's intentions are or how they intend to go about them. So we wanted to basically, end our concerns this evening with this being placed upon TECO, knowing that we've been good neighbors to a lot of people, and we would like to be good neighbors with them, with their intentions, but we want honesty and openness. Thank you and good night.
Mrs. Knowles, thank you for your testimony.
Okay, thank you.
We have Nancy Cunningham.
Ms. Cunningham?
I'm a special one, and I am right on board with the Knowles. My electric actually all runs underground because I don't like the wires. My property is the most secluded of all properties.
Ms. Cunningham?
Can you say your name and address for the record? Thank you.
Nancy Cunningham, 3406 G7 Ranch Road, Ruskin, Florida, 33570. I am the most secluded property on this road. So I do want to know what Tampa Electric is going to do with the property. All of my power lines run underground. So no, I don't want above ground power lines. I also live at a dead end road for a reason. I don't like traffic. So all of these things, Tampa Electric wants to propose agricultural. It's already being farmed agricultural. There's cows out there. There's agricultural right across the street from me. I don't mind them farming. What I do mind is the unknown of what Tampa Electric plans on doing with this property. And I would like further clarification. I'm not going to agree to this, and I'm definitely opposed to it at this point.
Thank you, Ms. Cunningham. Thank you for your testimony. All right, County Development Services.
Nothing further unless you have questions.
All right. Applicant?
Good evening again, Kristen Mora, Tampa Electric Company. As I stated earlier, we do not know exactly what the use of this property is going to be at this point. But it is possible that it will be a solar farm. That is one of the things that Tampa Electric does do, is build solar farms. So that is certainly a possibility at the time that we would go to develop. If that is the use down the road, then we would certainly reach out to them. I would like to reassure the neighbors that there are requirements if you do build a solar farm in this type of zoning category. There has to be a 50-foot setback, for example. There's some screening requirements in the land development code, all found in section 611-125. Oh, it looks like I've got it the wrong way. It says top. You'd think I could read directions. So there are some restrictions that are in the code. We're not looking to change any of those. In the event that we went and built a solar farm, we would comply with the land development code and all the requirements in there. So I hope that gives them some reassurance that we're not looking for anything special or special favors here. We just would like an agricultural district, which gives us some flexibility to use any of those uses within the agricultural district currently for agricultural, and in the future potentially for one of these uses or something else allowed in the agricultural district. If we sought something that was not allowed, or if we wanted to change something in the future, we'd have to come back here and give more concrete plans about what we were going to do.
Okay.
Thank you.
Okay, thank you. All right, that closes the hearing for item 20-0801.
The next item is agenda item D3, is rezoning PD 20-1148. The applicant is Motor Enclave Tampa LLC. The request is rezoned from AR to Plan Development. Israel Monsanto will provide staff recommendation at the presentation by the applicant. I will note before we get into the presentations that this item has a related comprehensive plan amendment, so this will be heard concurrently with that comprehensive plan public hearing, which is scheduled on January 28th. So this item will be heard on January 28th. Concurrently with that, it does not change your filing deadlines or the oral argument filing deadlines because they all occur prior to this date. So the dates that were read in earlier by the county attorney's office regarding report deadlines and oral argument filing deadlines for anyone who's wishing to speak to the board on this zoning item will not change. It's just that the meeting date in front of the Board of County Commissioners will be January 28th. With that, after, again, presentation by the applicant, Israel Monsanto will provide staff recommendation. We did hand out some revised a report with had revisions to conditions and also revised transportation, and staff will address those as part of our presentation. Thank you.
All right, applicant.
Good evening, zoning hearing master. My name is David Singer with law firm of Shoemaker, Loop and Kendrick, 101 East Kennedy, Suite 2800 here in Tampa. I am joined tonight by colleagues from Stantec, Adam Carnegie, colleague from Razor Transportation, Mike Razor, the applicant, Brad Olashansky, and my colleague from Shoemaker, Colin Rice, who is present in the room with you. The former are virtual with me. This is a 191-acre site located between the Tampa Executive Airport and I-75. The current zoning is agricultural. The current future land use is Res 1. We're looking to change to a PD zoning with an LIP flu designation. The site currently is vacant. There is an old landfill under this site. There is residential just to the south of this site. The project is going to be an auto enthusiast community. There will be 350 auto-focused garages, a vehicle performance track, a vehicle off-road track, a multi-use building, and a lot of open space and preservation of natural resources. And we will get into the location and purpose of all of those in a moment. We've worked with staff for over a year on all aspects of this PD rezoning. We are very pleased to have earned a recommendation of approval from land development staff, and we've worked hard to come to agreement on conditions for this PD site plan. The staff report is comprehensive. We will go through a few items and categories of particular import, and we'll be available to answer your questions should you have them. At this point, though, I would like to enter a binder of materials. We've consolidated all relevant materials into one place for your ease in going through this application. And my colleague Colin Rice, who is in the room, can hand the binders up to development staff, and we will enter those into the record. When we conclude tonight, we'll ask that you take all the testimony and the items put into this record into consideration and ultimately make a recommendation of approval to the Board of County Commissioners. So what is the project? It is an auto enthusiast community where people who like and own cars come together to store and drive those cars safely in spaces that they own. These garage spaces range in size from 600 square feet to 1,500 square feet, and you can see them depicted on the south and central parts of the site. The white buildings are the garage buildings. So owners drive their cars on a performance track, and you can see the performance track is about 1.5 miles long, situated along the center of the site, curves around. It is designed by a German track designer. And then there is a smaller off-road track on the northern 30-acre part of the site, where the cursor is now. The multi-use building is represented in blue in the southeast part of the site plan. It has additional storage for cars so they can be stored vertically on racks and with lifts. Also, this space can host corporate events and trainings. There can be corporate retreats. There can be educational seminars. There's a very small private gift shop for members where they can buy auto-oriented collectibles, usually from car manufacturers. Car dealers and manufacturers can use the track for testing and for education purposes. Law enforcement can use the track for training and for education purposes. There can be 5Ks out there and bike races out there. What there cannot be is automobile racing. This is not a racetrack. And we have specifically conditioned on the PD in 1.2 in subsection B that this may not be used for vehicle racing. And that's important for a number of reasons. In addition, as you can see, this development is very low density. It actually has an FAR of 0.08. It is purposefully designed around the natural resources on the site and to very minimally impact any conservation wetland areas. The applicant team has worked and will continue to work with EPC and with SwiftMud as the project advances into permitting. Again, note where this parcel sits. It is between the executive airport, which you can see on the backslide there, and I-75. And the project site is outlined in blue. As you go into the blow up of the project at the bottom, you'll see the garage buildings again are to the south part of the site. The multi-use building, again in blue, is away from residential and next to the highway on the southeast part of the site. The performance circuit itself is buffered by the garage building to the south, significant tree buffer to the east and the west, the airport to the north and the west, and I-75 to the east. There are several conditions, as you will see in the staff report, that staff and applicant agreed to add to the site plan. I do not need to go through all of them. Two that I will point out in particular. One is the track may only operate during daylight hours. That's again in condition 1.2 subsection B. And there is no head-to-head vehicle racing. Again, not a racetrack. It is a performance circuit. Again, 1.2 subsection B. Car owners here can drive in a safe and controlled environment. There's driving schools. At corporate events, people can be passengers in cars with professional drivers. Car dealers and salespeople can learn about the cars that they sell, and people in general can come here together to enjoy and appreciate the automotive lifestyle. Transportation conditions were worked out with staff and were based on the several uses on the site. This is a regional recreational use, therefore it is not residential. This is one of the main reasons we went with the LIP category for the future land use application. The LIP category precludes residential use. Another reason is that it demands that a PD zoning go on the site, so as to ensure there is a measure of control and assurance of compatibility by the local government. If this is designated LIP, there must be a companion PD site plan attached to it. There is some event space on the site. Again, you can see that in the lower right-hand corner, the multi-use building and the vehicle pad. Just to the north of that, there can be some events out there. There's really no particular use category that this development fits into in our code. So staff and the applicant work together to create conditions that can create a successful development. And I think the sort of tacit agreement was, think of the use category more like a marina, but for cars instead of boats, and then add some event space to it. And that's how we came up with all our projections, our numbers, our requirements, our buffers, our setbacks, and everything involved in designing the space. Here you can note the very intentional preservation of natural resources and conservation wetlands, and those are referenced in the green bubbles. The entire site is designed around them, and you can see that condition 9.6 requires extensive preservations of the wetlands. Also, if you can note the buffers and the screening around the perimeter. On the south there, that's a 100-foot buffer. And as you'll see in the staff report, the buffers are consistent with staff's direction and Land Development Code section 5.03.06 C6. The buffers and screening exceed the requirements of the Land Development Code. Again, 100 feet on the north and on the south. Specifically on the issue of transportation and access, a traffic impact study was conducted, it was completed, it was dissected by both the staff and the applicant, who then worked together on the site plan conditions to accommodate the various uses on this site. Now, originally, access was planned for Eureka Springs Road, very small road, very residential. After discussion with staff and with residents in the area, that changed so that access now is off of Falkenberg. Road improvements are required to be undertaken by the applicant on Falkenberg and on Sly. You can see all of these improvement conditions in exhibits E, F, G, and H in the binder. And if you have questions about access or transportation, Mike Razor will be happy to answer them. The last thing we'll address in our main presentation is the compatibility of the site and community support. And again, I won't go through the entire binder of references for future land use objectives that this project meets, but they are there for the record should you need to reference them. I will point out a few things about compatibility. Number one, this site has a landfill under it. Hillsborough County still actively monitors that landfill. Number two, this site sits directly next to an airport. These two things make residential use on this site impossible. Florida law prohibits most residential use so close to an airport. A full discussion of this prohibition is in the binder that we submitted. So currently, if not the 191 homes that technically could fit on this site, even though they will never be built because it's so close to an airport, it's on top of a landfill, what can reasonably and compatibly fit here? And the answer is a regional recreation use that is very low density. Again, this project has a proposed 0.08 FAR, a very low intensity and an excellent transitional use between the airport, the highway, and residential to the south. The applicant is also able to connect to public utilities, even though this is just outside the urban service area, due to a public health hazard exception, due to its proximity to the airport, agreements that the airport have with the city and the county, and those justifications can be found in exhibits Y and Z of the binder materials. All of the compatibility issues, the land use objectives, and the policies were very thoroughly discussed at the October 12th Planning Commission hearing, where the Planning Commission board voted unanimously to recommend a finding of consistency for the LIP designation in the comprehensive plan. When you review the staff report from Development Services applicable here to the zoning, you will see all of these issues are extensively addressed, including transportation, environmental, buffering, screening, utilities, and compatibility. The applicant agrees with staff's findings on all of these matters. The one area where the applicant does not agree with the staff report is where the Planning Commission staff in section 1.4 does not recommend consistency with the comp plan. Now recall, this was extensively discussed in front of the Planning Commission board, who again voted unanimously to recommend a finding of consistency for this new designation to LIP and away from Res 1. In section 1.4, the PC staff makes some conclusory statements that the zoning plan is not compatible with a residential designation. This is why we're seeking to change the comp plan and why these two applications are running together. We would respectfully point to policies 1.4 on compatibility, 16.2 and 16.3 on gradual transitions of intensity, community design components, section 5.1 on compatibility, and specifically goal 12 in those objectives and those policies. And we understand that there is an existing community plan that calls for residential here, but it's simply not realistic. It is aspirational at best when it was created in 2008. It hasn't been updated. Those plans should be updated every 5 years. This one was not. The airport and the landfill issues preclude residential from happening here. We would ask you to look to the sections I just outlined for purposes of consistency with the comp plan and take into account that companion application, which was, again, was unanimously recommended for consistency by the Planning Commission board. From a community perspective, extensive community conversations have been had between the applicant and the neighbors, Zoom meetings, in-person meetings pre-pandemic. You can see here in the numbered boxes, the landowners in the neighborhood to the south who either actively support or have no objection to this rezoning and this project. Most notably, in terms of supporters, it includes the 3 landowners who are the direct neighbors to the south of the site, numbers 1, 2, and 3 on this exhibit. There are letters of support from residents who could not be here tonight, and that is in Exhibit U in the materials in the record. We understand there are concerns expressed by some residents, and they fall actually into two main categories. One is protection of wetlands. That concern is very easily addressed. The applicant has been working with the EPC, with SwiftMud to ensure the protection of conservation wetlands. Very, very little will be impacted. Frank Hearn actually is here as well as part of the team, and my apologies to Frank that I did not introduce him at the beginning. If you have environmental questions, Frank will be here to answer them. Natural Resources provided comments and conditions, which the applicant will agree to, that include compliance with tree removal, preservation, screening, plant wildlife surveys in accordance with the Land Development Code.
Mr. Singer?
Yes.
I'm going to add 5 minutes. Will that allow you to finish?
Yes, absolutely. I will finish in less than that. I appreciate it.
I have some questions too. Thank you.
Protection of the wetlands is important to the community. It's important to the staff. It's important to the EPC. It's important to the applicant. Lots of agencies are touching this. They will continue to be involved. Again, Frank Hearn can answer environmental questions. The second concern from the community seems to be about the development process in general, mostly that the site plan will be changed once it is approved. I will assure you that that is not the case. As you know, as county staff know, very little can change on an approved site plan with the PD. That's part of the reason the Planning Commission recommended consistency with the LIP designation, as it affords compatibility protection since it requires that companion PD. I would suggest if other developers in the past have made changes to maybe non-PD development plans, please don't hold that against this applicant who intends to comply with the requirements of a PD zoning district. Lastly, we have videos from supporters on flash drives that were included in the binder. We'll ask that those are played at the end of the proponent's time for testimony. They will be helpful to understand the broad base of support. And to conclude, again, I appreciate the extra couple of minutes. And again, our team is here to answer your questions with the support of Development Services, a unanimous recommendation of consistency from the Planning Commission, with neighborhood and community support. We have an exciting and a compatible PD site plan that has been thoroughly vetted, and we ask you to concur with the applicant and the staff and recommend that this rezoning be approved. That concludes my application.
Mr. Singer, first of all, I received your materials. Your colleague handed them out. The clerk has them also. So I've got your traffic impact study. I've got your big binder full of materials, and thank you very much for providing this comprehensive information. I have just a couple of questions. I guess there were some changed conditions. In the original staff report, there were references to the cars that would be driven on the track being street legal, and that's been changed. So can you explain the difference in street legal or not and why, and particularly as it might pertain to noise?
Sure. We were uncomfortable with street legal being in the staff report because it didn't have a definition. We don't know what it means if something is street legal or not street legal. And so it would be very difficult in terms of enforcement. There's no intention here for very noisy cars to be on this track. In fact, we understand we're subject to the county's noise ordinance. We understand that we have a condition that we're subject only to run the track during daylight hours. But the intention for removing that language was an enforcement issue. I didn't know how to advise the applicant since there's no definition in the code.
Thank you. I noticed that part of the folio is not included in the PD. Is anything that property is not being or not planning to be used in conjunction with this this venue, or could you talk to that just briefly?
That's correct. That other piece of the property has no connection to this. We are only rezoning the outline that we showed earlier. the 191 acres will be part of this PD. The other property has no part of this.
All right, and I was just curious, briefly looking through your binder, I see there's a conservation easement. What does that pertain to?
Is that something we want Frank to?
Conservation easement to the Water Management District.
Sure, I'm going to ask.
I guess it goes.
You're on mute.
Pardon me?
Go ahead.
Okay. Madam Hearing Master, my name is Adam Carnegie with Stantec, planner for the project, 777 South Harbor Island Boulevard. The conservation easements are very helpful amenity, as it were, right next to our project. And if we could please pull up even the more general concept plan, I'll show you where the conservation easement falls. An aerial is fine, anyone will do. That's good. The conservation easement, Madam Hearing Officer, extends from our property line for the entire length of Falkenberg Road all the way down to Sly Avenue. So it is the area that we're circumscribing on the aerial that you're seeing. So that conservation easement means a couple of great things for this project. It means that there will never be any use of that property for uses with which we have any kind of compatibility sensitivity. That is why we have placed one of the reasons why we have placed the multipurpose building on the extreme eastern portion of the site, because it is next to what will always be a conservation area. So that easement was provided just so you know that there is a document that locks that in for no development going forward in perpetuity. Does that answer the question?
It does, thank you. All right.
Can you restate your name for the record, sir?
In a minute, as soon as I untangle myself. Yes, it's Adam Carnegie, C-A-R-N-E-G-I-E, and I'm with Stantec. Is that good?
Yes, thank you.
Okay, thank you. Thank you.
Just one more quick question. This is probably for Mr. Singer. And just because I'm curious, ownership of the garages, the staff report indicated they're going to be privately owned.
Yes, I can address that as well, Madam Hearing Master. Yeah, these are units that will be sold fee simple to the ultimate owners. Now, of course, the performance circuit, multipurpose building and so on will be owned by a property owners association and managed as such. But these are units that they're more akin to townhouses in terms of how the various units relate to each other. And there are conditions that we've worked out with staff so that the platting of these units can go forward with very clear directives on how the plat would be put together. But these
So that was my question, whether there was going to be a platting and sale of the fee simple land. So.
Yes, ma'am.
Okay. Are there similar venues and other places that are comparable that one might look at?
So the applicant, again, David Singer for the record, the applicant, this is his second project. The first one is in existence in Pontiac, Michigan. And so this will be the second motor enclave project. But yes, this concept exists. And we can show a brief picture. If you look at the bottom to the left, you'll see the motor enclave project in Pontiac, Michigan. It is surrounded by residential to the west and to the south, and then commercial and residential to the east and to the north. It has been extremely successful, and it's been in existence for 4 years. I'm not positive if we included it in the binder for the record, but we have several public officials from Pontiac who wrote letters of support encouraging Tampa and Hillsborough County to approve this and how wonderful of an addition it was to the Pontiac community.
Thank you. And I have looked at the party of record letters that are in file. I have seen the support letters. I've seen the opposition letters. And I was going to ask about community meetings, but you addressed that already. So that's all the questions I have for you. Thank you. And we'll go to proponents and opponents. Are there any? I'm skipping myself again. Development Services Department, please.
Good evening, Israel Monsanto Development Services. Madam Hearing Officer, before I start, as you know, there is a revised staff report and we have some edits to conditions. You will see a strike through and underline formats to follow the changes, and most notable revisions are found in condition 1.1c, as you mentioned it. I'm sorry, the first condition change is 1.1c. That one is requiring the posting of events over 260 vehicles to be 7 days prior, to notify those prior to nearby residents instead of 14 days. And this is consistent with the notification timing for county code enforcement staff that you found in condition 19. The condition 1.2b on page 19, that's the one that you were referencing on page, again, page 19, being amended, removing the reference to street legal vehicles. The applicant had provided revised narrative since November, removing this reference, and staff inadvertently left it in the report and conditions. The PD will prohibit races or competitions, and our land development code, again, does not define street legal vehicles. Therefore, the prohibition of any type of races will still apply to all types of vehicles using the circuit. On page 20, condition 2 is being amended, and also conditions 33 to 35 on page 26 are being added for lot development standards and shared access standards to allow individually platted storage garage units, as the applicant explained it. The applicant proposed to subdivide the units as individual lots to be sold, and these conditions will accommodate for the minimum lot sizes, setbacks, and access consistent with the proposed units being divided. These standards do not change the minimum building setbacks as shown on the general site plan from the PD boundaries for all the uses proposed in the PD. So all the setbacks for buildings along the south, east, and west will remain. Transportation staff have also updated conditions, replacing references to the corporate event center to a multi-purpose building instead, as well as updating condition 30 for the provision of sidewalks within the project. And those are mainly the updates to the report, but you will see those underlining and strike through. I will share my screen here quick. Can you see that?
If you can.
Okay. So as stated by the applicant, the proposed rezoning from agricultural rural to plan development PD is to allow the development of the site with an automobile-oriented recreational project. The site is 191 acres in size, generally located at the northwest quadrant of I-4 and I-75, east of Tampa Executive Airport and west of I-75. The site is also subject to a proposal future land use change from Res 1 to light industrial planet. Staff recommendations as outlined in the report submitted by Development Services is predicated on the site being designated with the LIP future land use. As explained by the applicant and according to the project narrative, the facility would consist of a gated community that would allow private garages on site. These garages are used for garaging of owners' automobiles and the owners and their guests' recreation and entertainment purposes within the community. There are also community amenities on site that would also be allowed under this PD, such as a gym, pool, putting greens, and open recreation areas where access to these amenities is restricted to the project's owners and members. The facility will include 3 development parcels. Parcel A, mainly consisting of 50,000 square feet of multi-purpose building and a vehicle dynamics pad. Parcel B consisting of a performance circuit and also up to 350 private garages and community amenities. And parcel C will consist of a stabilized course for off-road driving experiences. The project will primarily serve members that purchase a private garage units. However, on select days, this facility may also serve to host scheduled events accessible to non-members or assemblies. The events may include restricted access, corporate events, driving schools, open track days, as well as other assemblies which guests and invitees from the general public may attend. The applicant has proposed conditions and as well as development services to limit or eliminate potential off-site impacts. The proposed project site is being rezoned to PD instead, and also proposes alternative strategies through this PD rezoning to ensure compatibility with the surrounding areas as described in section 61180 of the Land Development Code for regional recreational uses. These strategies include conditions being incorporated into this PD zoning district. These conditions address noise, location of uses, outdoor lighting, and utilizing law enforcement to assist with traffic, among other strategies. Additionally, to ensure that important project
Go ahead,
design
Mr. Monsanto. Will another minute allow you time to finish?
Yes.
Thank you.
We're also, as part of condition number 9, including critical design features to ensure that those changes to those conditions will require a rezoning or a modification to the PD. Zoning districts in the immediate area of the subject site consists of residential and agricultural uses, including single-family homes. Current zoning of the site would permit the regional recreational uses subject to buffer setbacks and other standards. The proposed PD will incorporate buffers and setbacks compatible with those standards. Buffers and setbacks at least 100 feet from residential uses along the south will be maintained in addition to existing vegetations. Location of the track 300 feet from the residential uses will also reduce impacts from the site. The 50,000 square feet multipurpose building is being located on the eastern portion of the site adjacent to the Interstate 75 away from residential. Activities in the building will be available for corporate events and other member gatherings. As noted before, the proposed events will consist of a small scale, up to 260 vehicles entering the site, and large events over 260 vehicles, but no more than 1,310 vehicles. These large events will be limited twice a month, and the applicant will have to post a schedule of these events in advance to notify area residents, as well as law enforcement and code enforcement staff. Staff has received concerns from citizens with the proposed facility. Most have expressed concerns with possible site changes being done without changes to the PD, impact to wetlands and resources, and noise generated for the site. The proposed conditions, however, will require rezonings and modifications to the PD, such as buffer screening, general configuration of development parcels, etc. And also changes to these critical designs will require approval by the Board of County Commissioners. Staff finds that the project with the proposed development standards, buffer setbacks, and operational standards is compatible with the area. The applicant has made efforts to reduce noise, visual, and use impacts. Natural screening will be provided to mitigate impacts to neighboring properties and maintain the natural escape of the area. The layout of the parcels, location of driveways, structures, and parking areas are being designed to avoid impacts. Frequency of the large events has been kept to twice a month, with limitations to the number of trips entering the site. Natural Resources has reviewed the application as well as the EPC, and they does not object, and they provide proposed conditions as part of this rezoning. Based on all these considerations, the staff recommends approval with conditions. With the exception of the Planning Commission, no objections were received from other reviewing agencies, and I'm available if you have any questions.
Thank you. Thank you, Mr. Monsanto. All right, Planning Commission?
Unica Mills, Planning Commission staff. The subject property is located within the Residential 1 future land use classification. There is a concurrent plan amendment to change the future land use designation to light industrial plan under consideration. The Planning Commission found the proposed light industrial plan consistent with the goals, objectives, and policies of the future Hillsborough Comprehensive Plan at their October 12, 2020 Planning Commission public hearing. A final decision by the Board of County Commissioners will take place at an adoption hearing on January 28, 2021. The site is also located within the rural area and the East Lake Orient Community Planning Area. The proposed request from Agricultural Rural to Plan Development to allow for an automobile enthusiast community is inconsistent with the goals, objectives, and policies of a comprehensive plan. The surrounding land use pattern includes a mixture of uses. Tampa Executive Airport is located west and north of the site. Interstate 75 abuts the site to the east. Immediately adjacent to the subject property to the south are agricultural vacant properties as well as single-family residential uses. Planning Commission staff recognizes that the proposed use would be complementary to the Tampa Executive Airport, though due to the existing single-family residential uses being adjacent to the south, Objective 16 and its accompanying policies were used in the evaluation of the proposed use. The intent of these policies are to protect existing neighborhoods through various mechanisms. Policy 16.1 and 16.3. Policy 16.2 states that gradual transitions of intensities between different land uses shall be provided for as new development is proposed and approved through the use of professional site planning, buffering, and screening techniques in control of specific land uses. In this case, Planning Commission staff has determined that the proposed use would not provide for a transition in intensity between uses, would not provide creation of complementary uses, would not fully mitigate adverse impacts. However, the applicant has made, and Planning Commission staff recognizes that the applicant has made a true attempt through the use of professional site planning with buffering and screening to mitigate impacts to the residential uses in the area. Even with the buffering and screening in place, given the proximity of the residential uses to the south, it would be extremely difficult to properly mitigate impacts such as noise. The Environmental Protection Commission, Air Division did express concerns regarding noise that may be associated with the proposed use and asked that conditions be put in place for mitigation purposes. When requesting non-residential uses, developments are to meet commercial locational criteria or request a waiver to said criteria, as outlined under Future Land Use Element Objective 22 and Policy 22.1. Commercial locational criteria customarily applies to neighborhood serving commercial uses. Because the proposed use does not represent a true neighborhood serving use as defined in the definition section of the comprehensive plan, the square footage limits as outlined under Policy 22.2 would not apply to this request. The site will be limited by the FAR of the light industrial plan future land use classification if approved. While Planning Commission staff recognizes that the proposed use does not necessarily fit within the confines of a typical neighborhood commercial serving use, the proposed use is still a non-residential use, and all non-residential use requests are to be reviewed for commercial locational criteria. With that said, the site is not located at a qualifying intersection to meet commercial locational criteria. The applicant has provided a waiver. The waiver states that the proposed site meets the intent of commercial locational criteria by avoiding strict commercial development, and that compatibility is being ensured through the proposed general site plan. Future Land Use Element Policy 22.7 states that locational criteria are not the only factors to be considered for approval of a neighborhood commercial or office uses in proposed activity centers. Considerations involving land use compatibility, adequacy and availability of public services, environmental impacts, adopted levels of service of affected roadways, and other policies of the comprehensive plan and zoning regulations will carry more weight than locational criteria in the approval of potential neighborhood commercial uses in an activity center. With the proposed uses incompatibility with the surrounding area, Planning Commission staff has determined that the proposed use will be too intense and not complementary to the surrounding development pattern in the immediate area, and would disrupt the gradual transition to the single-family lots located immediately south of the subject property. Planning Commission staff recommends that the Hillsborough County Board of County Commissioners not approve the commercial locational criteria waiver. The applicant is proposing a 50,000 square foot corporate event center within Pod A, along with such uses as catering of events, car storage, and an associated 1,000 square foot retail space. The corporate event center may be used by members or by non-members, such as corporate users for special events. As per conditions, special events can take place up to twice a month and allow up to a maximum of 1,300 vehicles. Allowing this use to be open to the public increases the volume of traffic and activity traveling along Falkenberg Road, which is a local residential roadway. This is inconsistent with Future Land Use Element Policy 16.5, which requires that development of higher intensity non-residential land uses that are adjacent to established neighborhoods to be restricted to collectors or arterials into locations external to established and developing neighborhoods. Pod B is centrally located within the site with a driving circuit and garages extending along the southern boundary of the site. The performance driving circuit and a maximum of 350 privately owned garages will be developed at a maximum of 605,000 square feet. Additionally, Pod B consists of amenities such as swimming pool and putting greens. Pod C is located within the northern portion of site, which will consist of a stabilized off-road experience. There are significant wetlands on the site. The proposal,
can you finish up in a minute?
Yes, the proposal qualifies for environmentally sensitive land credit, policy 13.3, which qualifies the site for well over 5 million non-residential square feet. The Environmental Protection Commission Wetlands Division has reviewed the proposed rezoning in its site's plan current configuration. A resubmittal is not necessary. Planning Commission recognizes that the applicant has made a true attempt at mitigating adverse impact to the surrounding development pattern with buffering and screening. However, mitigation measures would not likely be able to achieve the degree of compatibility needed to the adjacent residential uses. The request also undermines the provisions of the East Lake Orient Community Plan, which envisions that new development should not adversely impact the existing neighborhoods. And based on those considerations, Planning Commission staff finds the proposed plan development inconsistent with the future Hillsborough comp plan. Thank you.
Thank you. All right, now we'll call for proponents. Are there any proponents in the room or online who wish to speak on item 20-1148? Yes, sir.
Colin Rice here for the applicant. We've just requested the support videos available. Oh, I'm sorry.
And your name and address for the record, please.
Colin Rice for the applicant, Shoemaker Loop and Kendrick, 101 East Kennedy Boulevard. We have support videos available. They're in the thumb drives. We'd requested those be played at this time as well at your convenience.
Okay, as during the proponents'
Correct,
time?
proponent videos.
Proponent videos, okay. Thank you.
Thank you.
Do you have those, Clark?
Sure.
Oh, okay. Thank you.
If we're online, are we allowed to tell?
Please stand by.
Hi, I'm Matthew Gibb. I'm current special legal counsel here in the city of Pontiac. To any other city that would be approached by Motor Enclave and has this opportunity presented to them, really stop what you're doing, get your team assembled and listen, because the creative aspect of this is something that you're not going to really ever see again. And the investment aspect of it is something that your community is really going to benefit and thrive from.
My name is Andy Meisner. I'm the Oakland County Treasurer. Oakland County's county seat is Pontiac. I think the Motor Enclave is a great investment for the following reasons. One, it's economic development. It is bringing economic activity and stimulus to the site where it's coming in. Two, I think it's a jobs creator. Three, it's adding to the economy by bringing something different. Nothing but good reasons to get on board with it.
I'm Michael Bouchard. I'm the Oakland County Sheriff. I've been the sheriff for over 21 years. Well, the kind of impact this has on lots of levels is that it's not just cleaning up a blighted, negative-looking piece of property. It's making a new tax base of that property for the community.
I am Deirdre Waterman. I am the mayor of the great city of Pontiac, Michigan. This is my second term as mayor. And one of the proud accomplishments was working with Brad Olshansky and his team to establish M1 Concourse right here in the city of Pontiac. The impact has been great for the narrative of Pontiac, and it has brought a great deal of attention to Pontiac because it's such a novel, wonderful site, and for car lovers and auto enthusiasts, it's had a great impact, and I'm glad that it's here. And the city of Pontiac is proud that we repurposed something that was outdated to something now that is next stage. I know each city will have different challenges because each locations are different in terms of they pick that up. But I would say to you that Brad is such a visionary. And I think that's one of the things I would also offer to other elected officials in the other areas, that Brad comes in with ideas not only of the profit motive for his particular site, but also how we could fit the neighborhood and the community and bring economic development and bring other kinds of people who are interested in it, because this is the kind of Pied Piper project that brings others to a community.
My name is Jeff Hulbert. I live at 10210 Twin Star Place. The property is next to the proposed Enclave project, and I support this project.
Hi, my name is Sharon Hulbert. I live at 10222 Twin Star Place, and my property is next door to the proposed Motor Enclave Park, and I do approve of this project. Thank you.
Hello, my name is Diana Lipke, and I live at 6434 North Falkenberg Road, which is adjacent to the proposed Enclave project, and I support the project. Thank you.
We also have two people signed up in support. Jeff Holbert. Jeff?
Yes, my name is Jeffrey Holbert, and I live at 10210 Twin Star Place. And as stated in the video, I do live directly next door to the proposed project. And I have also communicated with most of all the neighbors close to and in the proximity of this project, and they are all talking of being in favor of this, all looking forward to it. And definitely, I'm looking forward to it. Thank you.
We also have Julie Madison. Julie, are you there? That's everyone we have signed.
I really can't even understand what you're saying. I'm sorry.
He was asking, there's applicant team signed up.
Sounds bad over here.
He was asking the applicant team signed up to support. He was asking they to speak in support, and since they're part of the applicant team, they don't need to. I think that's part of the rebuttal. So if there's no other support, then we can go to opposition testimony. If there's anybody signed up for opposition.
Madam Hearing
Thank you,
Officer.
Mr. Grady. One more in support, or do we go to?
Yes, we have a couple that we're watching online. Eric Larson, P.O. Box 82497, Tampa, Florida. I wish to support. I'm sorry?
You marked down that you were signed up for the applicant team. Are you saying you're in support?
Yes, for the applicant team. Well, we're in support of the application. We're not on their team.
Go ahead.
I'm sorry, I'm having.
Go ahead, sir.
Mr. Larson?
Yes, ma'am.
You can proceed.
Okay, Eric Larson, P.O. Box 82497, Tampa, Florida, signing up to speak in favor of the applicant and approval of this project. That's all.
Thank you. Any other proponents who wish to speak? I think we have one more.
Yes, ma'am. This is Mark Sharp, 2200 East Fowler Avenue, the director of the Tampa Innovation Partnership. I'm here to speak strongly in support of the applicant and the application. I've had a chance to review carefully the project, as well as looking at imagery of the M1 project in Pontiac, where that project sits right in the middle of their community of 60,000 residents. And what was really good to hear was that the mayor of Pontiac and the residents of Pontiac wholeheartedly supported Mr. Olchansky and his project. This is exactly the type of project we need in Hillsborough County. It will create jobs. And you heard several of the government officials in Pontiac talk about creative enterprise and innovation. That's what our community needs more of. Business individuals who are willing to risk capital to come to Tampa to bring a project like this that will attract other companies and businesses, which we believe will be of great benefit to the entire Tampa Bay region. We know that the residents of Hillsborough County will deeply appreciate this project. It's exciting and will also attract innovation and research. So for those reasons, I'm strongly in support of the project.
Thank you, Mr. Sharp. Anyone else, proponents who wish to speak to this item?
One more, if I may.
Go ahead.
Eddie Birch, 5475 Friars Way Drive, Tampa 33624. I think this is a really exciting facility, and I just want to speak in favor of it. I'd like to see Tampa have something like that.
Is there anyone else?
Anyone else who wishes to speak in favor of this item? Okay, we'll go to opponents. Is there anyone who wishes to speak in opposition to this item 20-1148?
I do.
We have someone in the room. Please state your name and address. Thank you.
Todd Pressman, 202nd Avenue South in St. Petersburg, Florida, number 451. Madam Hearing Officer, I'm here as an agent for Mr. Ramstone to note a number of points for you. First of all, I'll submit in the record a number of comments from Pontiac, Michigan neighbors who indicate great difficulty with noise complaints there. This is from Google reviews. Quote, they're so loud and considerate. This is the most annoying place on the earth for me. I live down the street. The noise is ridiculous. It's too loud. Community cannot afford their events. Can't believe the city of Pontiac allows this to be built in a residential area. There's another element which hasn't been discussed as I understand it, is which is on the site plan, called a dynamic vehicle pad, in which on YouTube videos, which I'll put in the record here, and YouTube videos produce tremendous noise, clearly produce tremendous noise, clouds, odors of that type of activity, which I assume because the dynamic vehicle pad would be the same use. Perhaps the applicant wants to clarify that or wants to refer to that. This is a photo of just a single vehicle on the racetrack producing, thank you, the same type of result as you can see here as well. And from some information that we found on a Facebook page, the question was asked if drifting, which is a form of this, would be allowable at the site, indicates that it would be. In regard to the landfill, our understanding is the landfill is a small portion on the north. I've researched that. That's what I've been told. But I think that's an important point to ask the applicant to clarify that, or for the staff. But certainly, as the Planning Commission does, we don't see it as a complementary or compatible use for the area. Looking through the Planning Commission report, they note specifically that even with the buffering screening in place, with the proximity of residential uses, it would be extremely difficult to properly mitigate those impacts, particularly noise. And as planning staff also noted, it's not located at a qualifying intersection to meet commercial locational criteria. Planning Commission staff also notes that it would be too intense and not complementary to the surrounding development pattern in the immediate area. They note that while the applicant has made efforts at a true attempt to mitigate measures, they don't think that it will be likely to be able to mitigate all these uses. And I think that's important. When I briefly looked over the EPC report, the EPC report lists quite a number of concerns, significant concerns. And I think when you look at the Planning Commission report, who state that they don't think that those conditions or those elements can be mitigated, that becomes really a tremendously detrimental and life-changing use for residents in the immediate area. And finally, the Planning Commission also notes that the site does not meet the provisions of the East Lake Orient Park Community Plan, which envisions that new development should not be adversely impacted. So I'll place these in the record for you, and we appreciate your attention. Thank you.
Thank you, Mr. Pressman. All right, please go ahead.
Elizabeth, I believe you're in opposition. You're muted, Elizabeth. Go ahead.
Oh, okay. Can you hear me now?
Yes, go ahead.
All right. I'm at kind of a disadvantage because apparently the applicant submitted a
Please
large.
state your name and address for the record.
Oh, Elizabeth Belcher, Sefner, Florida. The applicant submitted a large file tonight, and I don't know if they've addressed all the issues that I'm concerned with. This application has been back and forth. It's been revised. There's multiple statements. Many of them seem contradictory. One point I want to make before I get into my statements is that the Pontiac location, is it on wetlands? Then going on, all through this application, there's been a theme of this being a conceptual plan so that they may change it as time goes on without major rezoning hearings. And they say in their application that they have shown all the facilities, the major facilities on this land. But they talk about a swimming pool, a putting green, a gym. They're not showing on the map. If they're saying that they're going to show all the major facilities, these things should be shown on the map to ensure that they're not going to be impacting any of the environmental wetlands. There's also, on the last map that I saw, there was a building called Off-Road Center / Site Maintenance Building that appears to be outside of the 50,000 square foot community events thing. And my question is this for a maintenance building? Is this to do body work, to do car repair? How are they going to address the pollutants that are going to be created by a garage, a car garage? Going on, they called it a critical design feature. They also state that at one point they stated that they were exempt from the noise rulings or the legislation or the rules in Hillsborough County, no noise requirements. When I asked the county employees regarding this, they said that they were not. But the only thing that I can see in the file is the statement saying that they are exempt. This should be clarified and made totally clear that they are not going to be exempted from noise regulations. There's also something on the general site plan. It says that they are allowed to have limited impacts to any edge of any such system that be permitted. They're talking about the wetlands. In other words, they can do some type of impact on the edges of limited impact to any edge of such system. And what does this mean? How far can they do this impact? Can they do it once, then come back again and again and again so that they totally get rid of the wetlands? I mean, the old statement is that, you know, you give a person an inch, they take a mile. There's also a discussion regarding the utilities. There was a discussion regarding the drinking water where they discussed wells and then said possibly they were talking about possibly tapping into either the city or county water lines. That has not been clarified. It really needs to be clarified because wells should not be placed on wetlands. As I was going back to they said the impact of the wetlands. Again, you know, if they continually impact small portions of the wetlands until there's no wetlands left. This parcel has been split by I-75, and the larger piece is the one that they're showing this on this map. But there's an upper piece on the other side of I-75, which they don't do anything at all about. And considering how the applicant continues to say that they want to be able to make changes in this plan without further zoning requirements, that should be shown in the map, on the map, that they don't plan to do anything with that piece of property at all. And let's see. What I'm saying is that at the very least, the applicants should resubmit an application that is accurate with all these major buildings, this maintenance building, the swimming pool, the putting green, etc., shown on the map. And also there's been many statements concerning that this development will bring in income, increase property taxes, increase jobs. However, what is it going to cost if they destroy our wetlands? How much is that going to cost us in our water resources, in both quality of life and money to restore the wetlands? Okay, that's it. Thank you.
Thank you, Ms. Belcher. All right, Development Services.
Couple of responses and questions. You'll note in the conditions of approval, there's conditions that address compliance with the Hillsborough County wetland setback requirements. They're in there. So we specifically require that they would have to comply with wetland setbacks pursuant to the Land Development Code, the regulations and the code. You'll note those are our report. Again, as noted in Israel's presentation, we have specific setback requirements for those amenities. That's for the garage owners regarding the pool and those other amenities. And so although not specifically shown in the plan, again, we specifically set up the parameters with the specific setbacks to ensure the proximity to adjacent properties, they wouldn't be there. So we did address those in the conditions.
Mr. Grady.
Sure.
Could you address, it's related to that, Ms. Belcher's question about the edges of the wetland systems? I think there was something that might have had to do with the setback, the wetland setback.
That's what I was addressing in my first comment is we have specific conditions that require compliance with the wetland setbacks that are specified in the code, because wetland setbacks are regulated by the county. They're not regulated by EPC. So EPC deals with impacts to wetlands. So to the extent that EPC does not or does prohibit any impacts of wetlands, then based on those wetland lines, you'll have a wetland setback. Mm-hmm. And so we've specifically required compliance with those wetland setback requirements that are in the code. The code does have some exceptions to certain things that are permitted in the wetland setbacks, but those are per the Land Development Code. So we're not making any special allowances for this application, and we're making them subject to the wetland setback requirements of the Land Development Code.
Thank you.
And I don't know if Israel or has any other additional comments to make beyond what I've addressed.
Mr. Grady, could Development Services address the questions about the pool and putting green and why those details are not required to be in the site plan?
I'll ask Israel to respond to that.
Israel Monsanto Development Services. So those uses are accessory and ancillary to the principal use, and they're also only available to members and owners. And we indicated in the conditions that those amenities will have to be placed at least 300 feet from the southern PD line, which are the parcels that consist of residential uses. So the track is placed at least 300 feet now. So technically those uses will have to be on the other side of the track. The gym will have to be enclosed, and that building could be at least 150 feet from the southern PD line, and those are even farther away from the actual garages. So while this is not like a PD specific site plan, the conditions will address those locations, like Mr. Grady said, the parameters for the location on the site for those uses. And also to the question for the noise, there is a condition also that will subject the site to the noise from applicable agencies, local and state agencies as well.
The standard noise ordinances, the EPC's ordinance regulations do apply to this use? Mr. Monsanto?
Yes, as indicated in the conditions, any local agency or state and under that umbrella will be county ordinances, EPC ordinances that will apply for this specific use, as indicated in the record from the EPC staff report as well.
Anything further from Development Services?
Nothing further.
All right, applicant,
This
have 5 minutes
Madam
for
Chair,
rebuttal.
This is Brad Olshansky. Can I speak? I'm the developer. Can you hear me?
You're with the applicant?
Yes, I am the applicant. Can you hear me?
State your name and address for the record.
Yes, Brad Olshansky, 42 North Speedway, Pontiac, Michigan, 48341. Olshansky is Oleshansky. I'd like to thank Madam Hearing Master for convening tonight, and I wanted to share some thoughts in response to a couple of the comments that were made. As you've heard, this has been a very lengthy process, over 1.5 years of pre-development, taking it very seriously, the concerns of the residents, the community, and greatly respect the staff and county commission, all agencies, for being extremely, extremely diligent in doing their jobs. With that being said, I think they can all attest to the fact that we have spent an enormous amount of time and money ensuring that we've complied with all of their concerns and adopting conditions to restrict anything that might be of a concern as it relates to traffic and vehicles and building types and setbacks and all that stuff. But specifically as it relates to a couple of the objections brought tonight, one is I would ask you to ask Mr. Pressman to identify where his client lives in proximity to the site, because I'm not familiar with that name being anywhere near the property, number one. Number two, specifically, as everyone knows, when you look at reviews online, you can always pick out one or two bad ones. I would encourage Madam Zoning Master to look at the Google reviews for my prior facility, M1 Concourse. There's over 766 reviews. There are a handful of negative reviews related to noise. Those specific noise objections and the pictures Mr. Pressman showed of drifting events and noisy events were in relation to very large scale public events, in particular called roadkill, which happens once a year at this property, which we cannot do at our Tampa facility. That event is so large, we closed down most of the city of Pontiac, including all the surrounding public streets. So the pictures that he's showing, the comments he's referencing are related to events that cannot occur, will not occur, and are just not part of our plan. Based on the location of the site and the limitations of the location. So I would say that that's not a good reference point related to the community comments. I think what's more important is comments from local officials in Michigan who clearly would not give their testimony on video and enter it into this hearing if they didn't support this project and see that as a benefit to the community. We would also not still be operating. I'm sitting in my garage in Pontiac, Michigan right now, and we would not be operating every day in the way we do if it was a significant concern of the local neighbors. And we are in a much more dense neighborhood, way more dense than we're talking about near our proposed site in Tampa. And actually, the majority of the neighbors, which I've spoken to extensively, had Zoom meetings, in-person meetings, have been very transparent and open to listening to their concerns, have supported this project and will continue to support this project, as evidenced by the comments tonight. And some of them were supposed to be on, apparently it must have had some technical difficulties. We even changed the location of the entrance. We've increased the setbacks. We've done all the things that the neighbors and staff have requested. So I would just leave it. The last thing I'll say is, Ms. Belcher, I respect greatly your concerns. I think we've tried to address numerous times, answering that we can't just willy-nilly build what we want. It doesn't happen that way. And we've spent months and probably hundreds of thousands of dollars ensuring that we've designed everything around the wetlands, because for two reasons. One is I want to preserve the wetlands. Two is I don't want to pay to get rid of the wetlands, which some developers just will pay and just scrape them and buy them somewhere else. And three is I think it's going to be a natural beautification, a natural setting for the project. So, I would say that I respect what she's saying greatly, but virtually all the concerns I've heard her raise numerous times are all being addressed in the plan. So I think that's probably my time, but I appreciate the consideration here, and I'm always open to more questions. And as everyone knows on the phone that works with me in the county, I can't be more open book as a developer.
Could you explain, please, other than using it for parking sometimes, the use of the dynamic vehicle pad in the Tampa location?
Absolutely. So that a vehicle dynamics pad is instead of being on a driving course, it's a small space. The predominant use is for car shows, which will comply with the limitation number of vehicles we've identified as a condition. They're used for autocross, which is a single car at a time going through cones, which is not a noisy proposition. In Michigan, in the event I referenced, which we cannot do there, they were used for burnouts and thrill rides. We can't do that. We're not doing that. So that concern, the pictures that Mr. Pressman showed are from that exact event, which is an event that had 50,000 people. We clearly have a limitation of 1,300 cars at this site. But the daily use of that is for small events and vehicle, sometimes they use it for filming television commercials for an auto company. Sometimes it's our members doing a driving through a cone course. Sometimes it's used for car shows with parking. And the main use is, in this case, is overflow parking to accommodate our largest events if we ever get as high as 1,300 cars, which is the max that the county would allow us to do. And that max came from plotting out car spots on that vehicle dynamics track pad and the track and our parking lots. So,
Mr. Lashanki, that I think is all of my questions.
Yeah, thank you.
Madam Hearing Officer, this is.
And with that,
Madam Hearing Officer, this is Adam Carnegie. I'd like to respond to one of your earlier questions about the EPC noise rule. If you'd like some additional clarification on that.
Okay, the time's up. Can you do it in 1 minute?
I can, yes.
Thank you.
EPC Rule 1-10.04 subsection 7 exempts this facility because it is not a motor vehicle racing facility. It exempts this facility from that particular noise rule. The county's noise ordinance, however, which prohibits, noises that are generally and maybe even more broadly specified as nuisances and so on, it prohibits those kinds of impacts. We are still subject to that. So I just wanted to draw a distinction between the two in the event that that was not clear enough. And then when it comes to the noise impacts, as Mr. Monsanto pointed out, there's a 300-foot separation of the performance circuit, a 100-foot landscape buffer, and the trees within that southerly landscape buffer are over 200 protected trees, all of which you will see in the conditions we have to protect. The buildings themselves are 27 feet tall and are positioned between the performance circuit and the property line. If you look at the DOT's requirements for noise buffers, which are in your binder, those are generally limited to 22 feet tall. So these buildings will be passive noise buffers, especially because this use is not going to be active. The track's not going to be active at night. So at nighttime, those buildings are sitting there being passive noise buffers to buffer even I-75's noise from these residents to the south. So I just thought that would help.
Thank you for that clarification, Mr. Carnegie. All right, with that, we're going to close the hearing for item 20-1148.
Can you hear me? Madam Hearing Officer, this is Cameron Clark with the County Attorney. Can you hear me?
We can go ahead.
Madam Hearing Officer, I'm sorry to add to the length of this one. I have one quick question, a confirmation from staff just for purposes of the record. The video that was shown tonight, there was some discussion earlier this week about that. I just wanted to confirm that a hard copy of that video in the form of a thumb drive or a disc was presented timely to the hearing tonight, so it can be preserved for the record so that the board can have access to it if needed. Correct. Yes, that was submitted.
Yes.
Yes. Awesome. Thank you so much. That's all I have.
Thank you.
Madam Hearing Officer, we usually take a break around 8 o'clock for the court reporter. I know we have one item left, but so if the court reporter needs a break,
Let's do.
We'll take a
10-minute break.
5 minutes.
All right, 5-minute break. We're recessed for 5 minutes.
Attention, we are live in 3, 2, 1.
We'll reconvene the zoning hearing for December 14th, 2020. And
Yes. The final item on tonight's agenda is agenda item D6, major mod application 20-1260. The request for a major modification of existing plan development. I'll provide staff recommendation after presentation by the applicant.
All right, applicant.
Hi, good evening, Madam Hearmaster Tyler Hudson, 400 North Ashley Drive, here on behalf of the applicant. With us here this evening is Sebring Sierra with the applicant, as well as Chris McNeil, the project civil engineer. I hope this is a situation where we've saved the simplest for last. This is it's a major modification, and I think hopefully in name only. This piece of property is within the Avila Golf and Country Club, which comprises a significant number of parcels, as well as a significant number of actual separate zoning lots, different PDs. This specific PD is actually only 58 acres, to the contrary of what's in the agenda. It contains 25 lots for single family homes and most of the driving range. Back in 2001, the PD also included set aside for 1,000 square foot accessory structure to a driving range. So it's an accessory structure to a use that doesn't itself have a structure. In 2004, there was a slight modification to the PD, minor modification, PRS. As time has gone on, it's become apparent that a 3,500 square foot accessory building would better serve the intent, which is it's really for an instructional facility that's related to the driving range. So that is the only change that we are here to seek. This is the only commercial portion of the PD, or I should say non-residential portion of the PD. Staff has recommended approval. We agree with all of the development conditions, and we respectfully request that you issue a recommendation of approval. I'm happy to answer any questions.
Thank you, Mr. Hudson. I don't have any questions for you right now. All right. Development Services.
Brian Grady, Hillsborough County Development Services. As noted by the applicant, this is a request for a major modification to the PD to add additional 2,500 square feet to the permitted 1,000 square foot accessory building serving the existing permitted golf driving range. This modification would result in a 3,500 square foot building. I would note I've handed out a revised staff report because there's a typo in the staff report which listed the increase as 2,000 instead of 2,500 for a 3,000 square foot minimum when it's 3,500 square foot. Notwithstanding, staff did find this approval, did not find any compatibility issues associated with this request. The location of the accessory building is sufficiently separated from existing residential uses by open space, internal roadways, the golf driving range itself, and the existing golf course. Staff notes there was an existing condition requiring maintaining a 200-foot setback from the eastern boundary, that's being maintained as part of this application. As noted, staff did find this request and no reviewing agencies objected. I'm here for any questions.
All right. Thank you. Planning Commission.
Unica Mills Planning Commission staff, the subject property is located within the residential 1 future land use classification, the urban service area, and the greater Carrollwood Northdale community planning area. The applicant requests a major modification to increase the square footage of the driving range accessory building from 1,000 square feet to 3,500 square feet. The intent of the residential 1 future land use category is to designate areas of rural residential uses compatible with short-term ag uses. The request to increase the intensity of driving range accessory building on the existing golf course is consistent with the intent of the residential 1 future land use category. The proposed change in intensity is compatible with the surrounding development pattern, consistent with Objective 16 and Policy 16.1, 16.2, and 16.3. The proposed modification is also consistent with the greater Carrollwood Northdale community planning area. The plan seeks to enhance and protect the scenic value of environmental and recreational assets by providing adequate opportunities for open space, recreation, and leisure activities now and in the future. The plan also seeks to ensure these connect to other systems outside of the community. The proposed modification further contributes to the community as a recreational asset and provides connectivity within and around the site. So the request fulfills the intent of the community plan. Based on those considerations, Planning Commission staff finds the proposed major modification consistent with the future Hillsborough Comp Plan and subject to conditions proposed by Development Services. Thank you.
Thank you, Ms. Mills. All right, so we'll go to proponents. Are there any proponents who wish to speak on item 20-1260? No. Are there any opponents who wish to speak to item 20-1260? No. All right. Back to Development Services.
Nothing further.
All right. Applicant.
Nothing further. Thank you.
All right. Thank you. So that will close the hearing for item 20-1260. And that concludes the zoning hearing for December 14th, 2020.
Thank you all. Have a good one. Merry Christmas.